I want to spend 3 minutes talking specifically about how estate planning can be botched in the administrative process after somebody dies. As an estate planning attorney who has spent well over 20 years trying to make sure that families are organized in the business of death and transferring assets, it is so frustrating for me to find that these plans don't get followed and therefore get frustrated. It's not until somebody dies that you go through the process of trust administration. And oftentimes, the surviving spouse doesn't realize that certain steps have to be taken. A surviving spouse has to take trust administration seriously if they have a potentially taxable estate, because there are certain steps that they need to go through in order to preserve the exemption, the estate tax exemption of the deceased spouse. So for example, we sit here in 2026 and the exemption is $15 million. If you have an estate, for example, that's 35 million or even 20 million, you need both spouses' exemptions so you can mitigate an estate tax bill at the death of the second spouse. This is not about wealthy celebrities or aggressive tax shelters. This is about your everyday person making sure that their family does not have to pay 40% of anything above the threshold to the federal government within 9 months of the date of death. A 2025 tax court case called Roland versus the Commissioner really demonstrated how things can go awry when the surviving spouse thinks, I don't need to do much. It's my assets. The trust says it's my assets. I don't need to file documents appropriately to preserve this exemption. Or perhaps they do, but they don't do it correctly. So let me tell you what went wrong there so that you can use this as a cautionary tale to make sure it does not happen with your family. It's an easy fix if it's taken seriously and if you get competent advice at the time of your spouse's death. So in that case, the wife died first. And what she did is say, okay, I don't have a taxable estate, so I don't need to file to get portability, which is a 706 return. She went on, she made her gifts, she made some changes to her estate plan, she ultimately died, and lo and behold, it turned out she was completely wrong, that the estate was taxable because she had not properly preserved the exemption of her spouse. To preserve the deceased spouse's exemption, you have to elect portability. So this means you've got to go through the filing of a tax return. Here's the other thing that happens. Oftentimes, people realize that they need to preserve the exemption, but they realize too late. So in the Roland case, she did file within the required 2-year period, but she used estimated values and she needed to use actual values. So what happened is that even though she filed appropriately, which many people don't do, she thought she went through the exercise, she thought she did it correctly. But as it turns out, because she used estimated values and not actual values, and again, valuation is a different topic for a different day, but we need to make sure that we follow what the IRS says in terms of what an appropriate valuation is. It has to be a qualified appraiser doing a qualified appraisal. And believe it or not, there's like a 17-point checklist that you need to look at and make sure that the appraisal that you've used is not a comp, it's not a letter, it's not a friend's opinion, it's not, well, I'm a real estate expert, therefore I have opined this is the value. But I digress because this is not about the valuation protocol. This is about making sure that you file the return appropriately and that you use an actual value that you can substantiate.